We may stop you to ask you questions. Do your best to answer your questions during most things we end like we just did. But if we ask too many questions, I'll give you some more time back to make sure you're able to present your argument fully. Whenever you start, I will start the timer.
Okay. Mr. Chief Justice, and may it please the court, the Student Body Constitution not only protects the formal act of voting, but also votes effectiveness in translating political will to representation. Under Students' Party v. Lewis, an election is deemed unconstitutional when its structure materially prevents students from exercising their political will. An electoral system that allows for casting ballots while nullifying the representational power does not satisfy the guaranteed rights of voters. Currently, under an at-large all-campus district for fall 2026, a single winner-take-all model is used for all 38 all-campus seats, distorting the representational effects of votes in various ways. In a two-party race, a block of candidates that receives 51% of the vote captures 100% of the seats, leaving the latter 49% with no representation. In a three-party race, a block of candidates can receive a plurality with 34% of the vote and all the seats, leaving a 66% with zero representation. The distortion is not cured through increased political participation. It's only magnified. As more viewpoints are introduced, more voters are rendered voiceless. As such, the structure penalizes engagement by predictably converting substantial votes into zero representation. No barrier is imposed on the standing of this case, as Article 5, Section 3b2 of the Constitution authorizes this court to act upon a written petition by any member of the student body for good cause shown, and imposes no injury in fact requirement. While the standing doctrine arises from Article 3 of the United States Constitution, the limitation does not automatically apply here. The court need not import said limitation if the governing constitution does not provide it. In the circumstance that a doctrine's standing is imposed, the requirements are satisfied. In Baker v. Carr, the Supreme Court ruled that voters have standing when governmental action diminishes the effectiveness of their ballots. Malapportionment and dilution are recognized voter vote-based cognizable injuries. An electoral system that predictably converts substantial vote shares into zero representation directly diminishes voting power. Petitioner's claim fits squarely within that principle, as it demonstrates a plain, direct, adequate injury in maintaining the effectiveness of their votes. Independently, the Lewis standard confers standing. This court has recognized that forward-looking threats to electoral fairness constitute unique concrete injuries supporting prospective relief. The fall 2026 map is registered to prevent votes from translating to representation in upcoming elections, which is a structural deprivation that falls within the Lewis standard. The imminent injury here is a predictable, systemic nullification of voting power. The design itself is a defect, not losing future elections. Under the fairness doctrine, this court has recognized that a Constitution's guaranteeing right to vote equals the right to vote in a fair election. Election is not fair if the structure materially prevents students from exercising their political will. Consolidating all 38 seats into a single at-large winner-take-all election inflicts a concrete constitutional injury on the right to a fair election. When the architecture of the electoral system predictably nullifies substantial political support within a multi-member body, it materially prevents the effective exercise of that will. The injury inheres not in dissatisfaction, but in the structure. The outcome of the fall 2024 election map case does not control this case's trajectory. Under Article 1, Section 4, this court's decision addressed that anti-majority status did not constitute a protected political opinion, but did not address where the electoral structure itself may violate Article 1, Section 2A through voter dilution or entrenchment. No previous holding resolved the questions of fairness or structural dilution presented. The central point of this case is the distinction between arithmetic, equality, and effective representation. Ballots may be equally counted, yet structurally submerged when electoral design predictably prevents a cohesive voting bloc from securing representation. Material prevention exists when architecture systematically notifies substantial political support across cycles without the requirement of certain defeat. Here, all 38 seats are aggregated into a single at-large contest, enabling durable entrenchment. A stable plurality can repeatedly capture 100% of the seats, preventing the emergence of a minority and insulating governments from internal electoral feedback. As a result, incremental correction to representation is foreclosed due to to the direct consequence of the design, which is not speculative. The predictable result is that vote shares from 40% to 49% are converted to categorical absence from representation. While the ballots are counted, representation within the legislature is not realistically produced. For any election occurs, voters are subjected to a system that precludes possible representation, causing a prospective architectural injury. The difference between one at-large seat and 38 is constitutionally significant when a single office produces a single voice while external disagreement occurs. By contrast, a district with multiple seats in the legislature exists to accommodate many voices for deliberation. The existence of 38 seats is a purposeful signal for a pluralistic representation. When a single winner-take-all contest fills all those seats, pluralism is defeated. Through 38 individuals of office, they are all derived from one victorious bloc that transforms the body into a single electoral mandate, which is a stark contrast to mixed representation from 38 independent districts, even under majority rule. By placing all seats in a single contest, uniformity is guaranteed when a state of plurality exists, transforming majority rule into total institutional capture that reduces the multi-seat body to a single seat. Now, the counter-argument may be that durable majorities are part of ordinary politics, with every ballot counted equally. However, equal counting does not address structural fairness. It addresses only numerical equality. Lewis provides a doctrine for fairness to decide whether the system materially prevents the exercise of political will when an electoral structure predictably eliminates the minority presence in the legislative body. It is not in line with that doctrine. Proportional allocation is not requested by the petitioners as part of this challenge. The structure totalization, which eliminates the chance for representation in a multi-member legislature. As such, architectural consolidation is the constitutional problem, not the majority's rule. Though equal ballot weight is necessary, fairness requires effective suffrage, a real opportunity for votes to influence representation. The structural inquiry is where the system prevents meaningful translation of political support into representation. The injury is concrete as a subsection of an electoral system that predictably nullifies substantial political support when the chamber gives rise to it, creating a violation of the design itself. The right to vote in a fair election requires structural fairness, not just arithmetic fairness from equally counted ballots. For these reasons, the Fall 2066 at-large map violates Article 1, Section 2A, and this court should order the Student Senate to refrain from implementing or enforcing Student Senate Bill 2025-1209 in future elections. Thank you. I reserve all the rest of my time for rebuttal.
All right, thank you. In terms of, can you tell me the facts of Lewis, the background facts?
Yes, so basically that case occurred in 2011. The petitioners filed a case to the Supreme Court challenging the supervisory elections enforcement of certain like election codes, the 700 codes, and they saw that the lack of enforcement could potentially violate their right to vote in elections. They argued that the supervisory elections failed to properly implement like safeguards for like computers, I believe, and that resulted in concerns that there was election security in that election. So they filed petitions for that case, and that resulted in the court laying out an injunction, and the court decided to lay out this entire like standard for fair elections.
Okay, that's good.
Yeah.
So the petitioners in Lewis, from my understanding, correct me if I'm wrong, is that they were casting their ballots in an electronic system, and the issue was that some things were marked incorrectly on the system, where they thought they were voting for one thing, but they were actually voting for another. So in terms of standing, do you see how do you think standing in this case compares to that case?
I believe there's a very big equivalence between both cases with standing.
Can you expand on that?
Yes. So basically, the standing in both cases, where it's like an electronic device for voting or a map, is that they're both considered an electoral system. And as described by the court in this case, students are entitled to a fair election with their right to vote. So when anything with the electoral system prevents their material will from translating to political representation, which is why they asked the question, where students materially prevented from exercising their political will, that's what it means by like the electoral system. Like they're challenging the electoral system because they believe the electoral system has prevented them from exercising their rights to vote, which is also a right to a fair election. And by a set of students not having the ability to exercise their right to vote or to a fair election, that impacts every single student in the state body. which makes a cognizable injury to every student who's participating in the election. Because what the court meant by fair election to everyone is a fair election to every single student. So the electoral system itself is being challenged. That makes sense.
I had a quick question, because I'm kind of thinking, I'm trying to figure out that part of this argument. Essentially, Lewis, their definition of political will is something that I think is different in this case. Can you describe, like, in your words, how would you define what the standing of political will is? Because that, I think, was not translating in these different cases, because I think the Lewis case, the computer system being an issue, like quite literally, when they went to go log in their right to vote, it impeded on the right to vote, either political will, versus here, I'm trying to figure out where the line is. You can like help me try to, I'm grappling with that, and that's not.
Okay, that's a very good question.
Right.
So, well, we actually kind of define it in the brief, but basically, political will in this context is taken from, I believe, political science literature. And basically what they define political will as is basically the preferences of the voters. Is that being translated by the electoral system? So I believe in both cases, there's a big equivalency between political preferences not being translated. Because with the computers in that case, they were malfunctioning, they were broken. So their votes were not translating to actual results. With this map, their votes are also not translating to basic political results because the map only awards the block of candidates that wins with 100% of seats. The people that voted for the losing candidates, any losing candidate with 49%, or where it's like 33%, they get no representation in the chamber. And that is the equivalent with the computer because it does, votes didn't count in the computer. They also win translating representation if it didn't count them out.
Okay, thank you.
Just a question here. I think what you're saying too is that political will is not just the right to vote, but the right to have the people that you're voting for elected. Is that what you're claiming?
Political preferences, it's the right to have a meaningful vote, not like always guaranteed to have representation. You know, in elections always winners and losers. But an election such as off campus with 38 seats, people with that much of the chamber, people who are electing, who are voting, they should be able to have at least some representation for the losing candidate because it's 38 seats. So in a multi-member legislative body, usually that that represents pluralism. There's like a majority party and minority party. But with this electoral system, it basically collapses 38 seats into one single seat, if that makes sense. It's one single electoral mandate. So instead of like maybe those 38 seats resulting in a majority party having 15 of those seats and a few other parties having 18 of the other seats, and majority party having 18 seats and the minority party having 15 of the seats. Instead, what happens is that the majority party, or just any party that wins, gets 100% of the seats. So instead of voters having ability to really voice their preferences, it's really just, their votes are just being counted for a candidate, but that doesn't really go anywhere if they don't win. That entire block of candidates doesn't win. It's either this block of candidates wins, they get 100% seats, and the other people don't get anything. That's what it means to be a winner-take-all system.
Correct me if I'm wrong, the apportionment is supposed to reflect population data based on people who live in the districts, right?
Right.
Right, so I'm trying to wrap my head around your argument in terms of the districts. Do you think that one district isn't like inclined to vote a certain way than another?
Well, that may be, but I mean, it really, like under the at-large vote, it combines any possible number of districts. I mean, there could be 10 districts for off campus, 5 districts for off campus, but with this at-large vote, it combines all those districts into one district. So really, representation for off campus, for any of those districts that may vote a certain way, it's really only defined by the majority vote from any one of those districts. So the preferences of any one district can be overturned if the majority from everyone else says the other thing. So I believe in our case, we actually mentioned a district called District D, the former District D, and they used to always vote for the party that loses, the block of candidates that always lost. And when this map was implemented, that district, their voices were quickly arguably nullified because they used to be able to vote for the losing party, the block of candidates. They would always win that district that preferred to vote a certain way.
Who's the they that you're referring to? Because this is the problem from the election map case that you're saying, you're distinguishing from this.
they in District D, these people, but it's not an identifiable class. There's no class that needs to be discriminated against here.
Right. What I mean by they, the voters. The voters that vote for the party that happens to lose. Those voters, they're not getting their preferences voiced into this map. They're
Well,
not getting
in
represented.
any
in this map.
political system, aren't there people who are voting for a losing party who aren't getting their voices represented? I mean, you think of like, if you think of like a state as a voting bloc, right, and only 2 senators get elected per state. There are states that are the majority one party versus another, right? And there are dissenting voices within those states that may vote a different way but don't get their outcome seen to fruition, right? And so in turn, they end up not getting necessarily their policy preferred because of the place that they live. The majority of the other people are voting a different way. Does that not happen in almost every other kind of electoral system? When you talk about political science literature, I mean, doesn't that happen in single member district systems? Doesn't that happen in proportional representation systems? Doesn't that happen when you have ranked choice voting? There is always going to be someone who doesn't get their policy preferences forwarded, right?
Well, I'm not sure that characterization will be analogous to this case, because we're talking specifically about a multi-member district that boasts of 38 seats, which is 1/3 of the chamber, representing a geographical area, which is basically a supermajority of the student body. Those students, which compose of a supermajority of the student body, unlike at a state, which might be composing like a fraction of the population, that's a supermajority of the student body that's attempting though, like all participating in this election have different political wills, they're voicing their political wills through elections, and only one certain group of students is having their political will voiced in these elections. 100% of seats are taken. All 100%, 38 seats are taken to that block.
May I ask what would be, like, what would you see your proper solution being, right? Would you see it being as wanting to see going back to districts where you may have districts that are dominated by a majority party often, and you may have like 1 or 2 districts who, like you said, happen to vote for the losing party? What would be your alternative solution that doesn't violate the Constitution or see people's rights or preferences not being articulated?
Well, it's really up to the Senate because they create the laws. The court here is only interpreting the law, and
I'm just trying to see the outcome of our case, though. Like, if we're going to rule a certain way, right? Or there's going to be an alternative. It's
Right.
either that this is still enacted, or there will be another alternative that is put forth. And I wanted you to think about like what would be the alternative. If we ruled in your favor, what would be the alternative?
I believe the alternative would be more of a return to a similar model with the multi-district model, where like it was more based on geographical region, and those districts were smaller, which would ensure that instead of like if the party that wins is very popular, they wouldn't be able to easily split the entire map because to get the entire popularity vote for the entire region. They would have to get the popularity vote for all these specific regions, all these specific districts. So at least when the minority party, if it's like split like 51%, 51% and 49%, that could be possibly seen in districts that might be more inclined to support the losing party in districts that might be more inclined to support the winning party.
So would 2 districts be enough? My question is, where's the line? Like, are we gonna have 2 districts, 3 districts? I understand that's a question for the Senate, but my issue is like, how is this redressable? Like, there's no bright line rule for how to distinguish these different districts. It was arbitrary to begin with. 32608 was District D. Why? Who knows? Because someone set that up 20 years ago, not because there was a cognizable interest of the people there. And like, I'm just struggling to see how election fairness as like this mysterious thing establishes standing for you in particular. I don't understand how you, as petitioner, have a concrete injury. We're talking about this like innumerable population in District D. But like, what is your concrete injury here? And how is it redressable by this court?
All right, let me answer all those questions. So the concrete injury here is that every single student is entitled the right to vote, which is also the right to a fair election. And the court has recognized in Lewis that every student should be able to have the right to a fair election. And when that election fairness is impeded by the electoral system, every student has a concrete injury to challenge that, because now, since one set of students might have been affected by that possibly alleged unfair election unfairness, that means every single student is now participating in a possibly unfair election. And this while this might be happening in the future, the court has recognized that students are able to file forward-looking claims on election fairness in order to protect the integrity of the student government and the integrity of people's rights to have a fair election and the right to vote. And the way this is readdressable by the court is that the court can rule this map unconstitutional, the at-large map, because the at-large map thus far has, for the past 3 elections, it's always been the party that wins that gets all 38 seats. In the past elections and previous districts, when the vote was more split, when 51% to 49%, the minority party usually always won at least 12 seats or 8 seats, depending on what district they won. Now it's just like the party that wins, they get all the seats. There's no reasonable way for a minority party to get any seats in this district, and that's the problem I have with this district. The problem is that, like, before, with the multi-district model, minority parties could at least have a chance to have some representation, even if they lose the overall vote for off-campus and overall vote for fall elections with
Sorry,
this
Jenna,
election.
who apportions, like, the off-campus, who apportions who can vote in different districts? Who sets that up, the system up?
The district committee of the student senate is tasked with apportioning.
Say that again, sorry?
The district committee,
Okay.
yes.
Another question here. In your brief too, you mentioned that multiple times that the dissenting coalition can never have the opportunity to gain a voice in the Senate. And I would just like you to clarify on that, because do you think it's possible that the minority or the party that happens to lose can never gain a voice in this type of system?
It would be insanely, what I mean by reasonable is that, like, it would have to come down to voters basically split ticket. And that's a very rare circumstance for voters to do so in student government elections I've seen in the
Well,
past
but
few elections.
in your brief, you don't say that it's not reasonable. You say that it's never going to happen.
Okay, well, let me clarify that. So what I mean by never in that description in the brief is that, like, the off-campus map has just created a electoral system way that is designed that when voters elect vote for a certain block of candidates, that block of candidates that gets the majority votes is always guaranteed to win just based on the sheer amount of votes. So, for example, the top
Wouldn't
candidate,
the other party win if a more percentage of people voted for the other party? Wouldn't they win then?
Can you clarify that question?
You're saying that because people typically vote more for one bucket of candidates, they always win.
Yes.
But wouldn't the other party, the other bucket of candidates win if more people decided to vote for that party?
Yes, but what would happen is that now that that party has the most votes, the other party that was always about to win has 0% of seats. Because it's a winner take all. Because since you are more important voting for a certain bucket, one bucket is always going to rise to the top, and the other bucket is just going to do that. That's why I'm basically just trying to the winner take all, and how I basically say it's never going to happen because, like, basically how it's designed is that, like, it's always going to refer to the party with the most amount of votes for their block of candidates. It's never going to be like, there's never going to really be a reasonable chance where a party has, like, both parties are basically tied in votes, and, like, it's like their block of candidates gets split evenly. Like, that's just not going to happen. It's usually how votes are distributed. One block of candidates wins the election, and the other block loses. They get nothing.
But isn't that like the United States electoral system as it's set up currently? What winner takes all?
Yes, but the winner take all for the United States system is usually based in single seats. So, like, for example, a Senate seat, that's a single seat. In this case, and like in the House of Representatives law, it's a single seat. In this case, this is a multi-member at-large district. In the United States, there's only single-member at-large districts. So these are multiple seats, 38 seats, which is more than a third of the chamber. And so when a block of candidates wins, they're basically almost guaranteed the majority of the chamber, since that's almost over a third of the chamber. So this winner-take-all system really transports the entire legislative branch into a winner-take-all system with one mandate. Transforms 38 seats to one seat, and those 38 seats are over one third of the chamber. So it transforms the entire chamber to one mandate.
Is there any precedent considering like this very similar election map as it is right now?
the only cases that go over this election map were about discrimination. This is not a discrimination case. We're not talking about protected classes being discriminated. We're talking about voters in general being subject to a possibly unfair election under this electoral law, where only one block of candidates, when they get the most votes, they get everything. And the other block of candidates, any other block of candidates, if you're gonna be 5 other losing blocks, they get nothing.
I'm just having trouble figuring out precedent that says there's something wrong with how it's currently set up.
Like, Yeah, even if it's not like a UF, also thank you for being here today.
Yes,
Even if
thank
it's
you.
not, even if it's not, a UF specific case, do you have like any kind of case that invalidates the winner take all system?
Well, there are a bunch of cases in the Supreme Court. You want me to go over them?
Just a couple.
All right, so I mean, it's kind of in the footnote, but there's a case called Waters v. Lodge, and there was a winner take all at large system in Georgia. There was this county. There was a black majority and a white majority during that time that case was filed, and basically what happened was that the white minority, who basically had more political participation due to socioeconomic issues that like made the black majority less inclined to vote. Like, you know, they didn't have good architecture with their roads, their education was worse, because they didn't get public funding, and the public election officials weren't really keen on helping them get out the vote.
Yeah.
Those people, when they elected their candidates through their blocks, they always wanted the seat for the at-large system.
But that system was targeting a certain race.
For the class of people, that's what I think we're struggling with, because that case clearly states a class of people that was voting discrimination, and that's their concrete injury. It was targeted for a class of people in a certain area. Whereas here, like you clearly said, like all students are not getting the right to a fair election, versus,
Yes.
which is a whole different set of legal issues, versus the Lewis case, where they were able to trace back to concrete actions that on each student's vote diminish their vote, versus this is like a general allegation that all students are not being represented when they are, but they're not being represented how their party is voting because they're losing, which is why we're kind of confused on how to.
Okay, so yeah, I was gonna get into that. Yes, Waters v. Lodge was a discrimination case, but the logic of that case carried over to unfairness, because disregard the black minority and white minority. Disregard the protected class. Those are voters participating in an electoral system where only certain voters are voting for the side that's winning actually get represented. The side that doesn't vote for the winning side doesn't get represented under that similar at-large system.
But this is just in this one at-large district, correct? The 38 seats, it's not all 50 that are arranged based on population rank, or whatever that word is.
38 seats, yes.
But what about the other 12 seats that are also based on, like, Beatty, Broward, Graham, Hume, Jennings, like, they still, so you're only, I think also the other thing that, I'm sorry, I'm focused on this point with the losing. So far, correct me if I'm wrong, this system has only been tested against a list of candidates from one part. It hasn't been challenged, right? Like, this is only in fall 2026 where one party was running in the district,
Fall 2026, fall 2028.
or fall 2025, my apologies.
Yes, but I like to bring this court's attention to fall 2023, which had a historically high turnout for the fall election, and the voter turnout between the parties. The part that won, the part that lost, it was more split. It was like, I believe 56% to 43%, and only one party got 100% of seats, and the part with the 43% got nothing of the seats. And I think the similar effects was seen later in fall 2024, with the winning party get 65% of the vote, and the losing party get 30 something of the vote, and the winning party gets 100% of seats, and the losing party gets 0% of seats. And I would even argue that in the fall 2025 election, there was a candidate that was running, they didn't get anything. But the point is, the winning party in all those elections, they are guaranteed all the seats. So it didn't matter if there was a party running against them, like in fall 2025, where there was some party against them. The effect was still the same. The winning party won every single seat. Even if it was a 2-party race, a 3-party race, it didn't matter. The winning party always won every single seat, disregarding however close the overall vote and the party vote for off-campus was.
Just revisiting standing for a moment. When we were talking about Lewis, and we talked about how they had a direct injury because of the way the system was set up. And when Lewis said that therefore any student voter had a cognizable injury, right? Or
Yes.
concrete injury because, do you think that was because every student voter had to vote through the exact same system?
No, it's about students having a fair election overall. Like, they may be subject to different electoral systems, but what the court clearly recognized is that every single student is subject to a fair election. So, yes, I mean, technically, not every student voted, not every student was off campus and they voted for off-campus candidates. Like, there's a bunch of on-campus students, but they also will be affected by off-campus being under this electoral model, this at-large model, because the court has recognized that if one set of students is not getting their political will, like their political purposes being materialized into actual representation in the chamber, that affects every single student, because every single student is guaranteed the right to a fair election. Now, fair election, fairness really generally means it applies to every single participant, every single voter. So yes, like every single student would be affected, even those that are not necessarily living off campus, if that answers your question.
Yeah, kind of. Yeah, my point was just that I think the injury, they allowed any student to bring a claim because every student faced the same direct injury when they went to vote at the polls. And I know you might bring up the in re-election conflict case.
Yes.
And you cited that again for standing issues.
Yeah.
But there is a footnote in that case that basically says it's entirely up to the discretion of the court on whether they want to grant a concrete injury standing for, claims of this nature.
Right.
So do you have any, can you reconcile that with your claims?
Yes, I would reconcile that by saying that that the court is totally capable of revealing whether there's allegation of infringement upon a student's right to vote. It's really a concrete injury. I would say that I also like to note that the court found that there was a concrete injury because of unique facts and circumstances. I would argue this equivalent here. There are unique facts and circumstances because you consider the totality of the circumstances here. You can realize that this electoral system has been in place for 3 years, and we have seen the same result for every single election, where it was 2 parties, 1 party, 3 parties. One block of candidates has always won the same, and we can see how that has affected student government. Voter turnout
But
has
it's like,
decreased.
you're talking about it, like the injury there in the election conflict case was a student, it was the hurricane happened, there was 2 days scheduled for elections. First day, they were able to vote. The second, it got rescheduled to the week after. And the student's issue was whether his vote was going to be counted. That's like remotely, not really close to the type of injury that we're looking at right here.
You don't think there's a equivalency?
It's just the type of injury that.
those are specific factual circumstances. You're talking about the structure and the system. I don't think they're analogous. I think a hurricane came 2 days later. That's very particularized. That makes sense as an injury. In Lewis, what was Lewis?
It was the election.
They thought they were voting for someone, they were voting for someone else, or their votes didn't go through. That's clear, particularized, like historical. You're not recognizing their right to vote. But here, it's just, that's what I'm showing. It's so ambiguous. It's like it's too abstract, which is like the basis for standing. Is it needs to be concrete. It needs to be particular. Like, did you run? Were you slated as a candidate? Did you run for elections?
No, I wasn't running, but I was a voter.
I would like in my dream plaintiff for this would be someone who ran one district D, was a senator, and then at large model dropped, ran, lost, because there's a particularized injury for that candidate. They suffered directly responsible from the mouth. They can at least allege that. Might not be true, but they would meet the standing threshold. You as a petitioner in this case, while I understand your argument, I see it election on merits, I totally see it. But the question is, does it meet prudential standing? Does it meet constitutional standing? And for you as the plaintiff, I don't think so, because you didn't run and then were impacted by this at-large model and then lost, and then you have a redressable claim by the court. You see what I'm saying there?
I'm not sure your claim is analogous though, because what the court ruled, according to the court in Lewis, it didn't matter if the person was a candidate for like a electoral system being affected, because the people that were actually filing this case, I mean, sure, they may have been candidates, but the
Didn't
court was
they
looking at.
vote and then their vote didn't count and they brought the claims because they were impacted as the plaintiffs? Because their right to vote was particularized to them and then their vote is not recognized, so that's their concrete injury as the plaintiffs, right? Wasn't it the people whose votes were not counted who sued in that case or who brought the claim?
There was the petitioner, yes.
Yes, but when the court analyzed the case, they weren't particularly concerned if it was just that specific group of people that came to file the case, because according to their logic, anyone who had knowledge of that could have filed the case themselves, because the right to a fair election, if those people were affected, other people could have filed a case on their behalf.
Is
and
that
argue
what Lewis says though? And I don't think that's what, I think in-rate election conflict specifically says that to walk back that broad, like, granting of standing by saying, hey, these are specific factual circumstances in this footnote, this is not the court saying there's universal standing, like, the court wouldn't say that, and that's the purpose of in-rate election conflict. In my reading of it.
Well, it wasn't like a complete doubt. They just gave them the ability to review the allegation of infringement and whether it was like truly concrete injury. They basically based their decision from what I read, based on the unique facts and circumstances. And I would argue that this case itself has unique facts and circumstances pertaining to the long-term effects of this at-large model. And as I was going to get before, through this at-large model, we have seen the chamber be continuously dominated by one party. There's less pluralism in the chamber now. Instead of like making the chamber split 50-50, it's now one party has the entire chamber.
Is there a right to the chamber to be split 50-50? Where is the right for that?
Okay, so the Constitution, like the court, according to like these cases, the right to a fair election and apportionment, they basically, there's a representational guarantee, and what that, like there's like a constitutional principle, like a representational guarantee, and what that basically means is that the court, while like you voters may prefer, uniformity in elections, like they may prefer to vote for one party, electoral system itself, it cannot be created to basically endorse that uniformity. There always has to be a way for pluralism to exist in a chamber, even if the voters want a specific, but just want entire dominance by one specific faction. It's just not allowed by the Constitution on that principle, and that is supported by the court in the previous cases. And basically, that's like a long-term influence of this map is that pluralism is increasing in change. A representational guarantee where voters can materially voice their preferences in elections and have their people that they want them to represent them to get elected has been decreasing on their small to the point where it's only the people who win that get any voice in the chamber. The people who lose don't get any voices, and that has been impacting off campus. Only one party can dominate off campus, and unless the other party wins the most votes, and that can create instability, where only one faction can win the entire region, or another faction can win the entire region. There's no basis for like compromise or pluralism. There's no minority representation at all under that model.
Do you see how in both precedents we're talking about how the facts of the case, the petitioners, the alleged issue is that both times it impacted their right to vote, their right to go to the poll, their right to express their political will. And so that's kind of different from this case, because there's no really restriction on whether we can cast a vote. It's just your issue is that when they cast a vote, it may not, result in someone getting elected.
Well, I would argue the effects are pretty much the same, even with, like, if it's like a period that breaks down and their votes are represented, or like their vote is not represented, because as I stated in my opening statement, there's a difference between arithmetic, equality, and actual representation. The votes, in your case, like, the period doesn't break down and the votes are actually counted, but the effects are still the same. Their vote is not meaningfully turning to anything. Voters might get 49% of the vote, but they lose and they only get 49% of the vote. They get 0% of the seats. Their vote for like the party that lost, the bloc candidates that lost, that means nothing now, because only one party got 100% seats. And I would argue that's the equivalent of a computer breakdown, they're both not counting. Like, let's say, for example, a computer breaks down, and there's like a bunch of people that wanted to vote for the party that lost, and only the people that got their vote counted was from the computer, is part that won. That's basically the same thing, like, their votes didn't count anything. It was only the winning party.
I think the issue is, in terms of setting precedent for future elections, what Justice Miller was referring to is it 2 seats enough? Is 3, are we going to redraw these same seats, add more seats? And then at that point, isn't it just going backwards on what you're saying, where we're looking at data where historically minority versus majority party people who are voting for these parties live, and we're creating a map based off of that? Because that, in my opinion, is almost going backwards and drawing these districts or groupings or whatever to benefit one party over the other again. So at that point, it just seems as though, again, like, the right to vote does not equal the right to be represented how you want to be represented when you're the minority party. So that's what I feel like we're all kind of thinking about here.
Well, I'm not sure I would agree with that characterization, because basically what you're saying is that, well, I'm not trying to say that we should endorse basically partisan gerrymandering districts. That's not what I'm trying to say here. And also that's up to the same, really, to decide the districts. What I'm saying here is that under this current system with 38 seats, which is a high number of seats in the chamber, it has basically transformed the chamber into a winner-take-all system, a winner-take-all, where one party that wins all those seats based on majority vote for the entire geography region, they're basically guaranteed a majority of the chamber. Whereas with smaller districts, while yes, parties may be able to win every single district, there's still a chance for the minority to win those districts, because the threshold, when, like, with the at-large, it's reaching the thousands, hundreds of thousands. With the smaller districts, it's with lesser voters. 100, maybe, like, for example, there could be a district where there's only 2,000 people that live there. And so the amount of votes that the minority might need is way lesser to fulfill, get 51%, and they at least get some representation with their blocky candidates. I'm not, like, asking for, like, we make 38 single-member districts. I'm asking for an electoral system that allows for the minority to at least have a chance to have their representation be counted through their right to a vote and the right to a fair election.
Looking at Lewis and the standard that you quote, you're saying, worsens which are prevented from exercising their political will. What is exercising their political will? What does that mean if not voting?
So, well, yes, it actually could mean, but I would also interpret exercising political will for also getting involved in the election itself, such as maybe political participation, such as, like, maybe supporting the parties with funding or buying their merchandise or looking at their platform. Exercise your political will, I mean, that's just more of a formal term. It really just turns voting into a formal way for people to promote their political preferences.
And how is
So-
that being impeded on
So
here?
yeah, how, they can do that.
How-
They can do that.
How is this map limiting someone from voting, from supporting a party, from funding a party, even if it's a minority party? How is this map in particular impeding that?
Because I don't think dilution of one's voice equals impeding on their right to vote, because that's how a minority-majority two-party system works. Ebbs and
Well,
flows
hold
of
on.
popularity of parties.
Well, let me clarify. So let me clarify. So what I mean by that, what it means for people to exercise their vote is the formal way to do it, which is through voting. That's the official formal way to do it. So when people vote, that's them officially making their political preferences known. Yes, people can fund parties, but, like, as you can see, one party can, there's gonna be 2 parties that get a bunch of funding, but it's a party that, like, it's, the party, it's only based on the party that wins, not based on funding. So really, the way people can really voice their political preferences is through voting. That's what it means to exercise their political will. And I'm arguing that this map doesn't allow people to voice their political will and have it materialize in reputation when it constantly translates, like, just a plurality of the vote, or, like, an actual majority, or, like, it can be a 3-party race, 34%, 33%, 28%, and that 34% is 100% of seats. So, like, maybe that party with 34% got, like, a bunch of funding, but the other parties got more funding combined. What I'm saying is that when people actually when they actually officially vote, and they exercise their political will, the party, it only is based on the party that gets the most votes. So that part of 34% is 100% seats, and the other part is 0%.
But the students voting for the 0%, there's, never mind. I'm following you.
Yeah. Thank you, Tyler.
Thank you.
Oh, can I do my rebuttal?
Oh,
There's-
yes. You get, what will you reserve?
Yeah. Is rebuttal only for a case where there's a petition going against each other?
Yeah. Unfortunately, there's no one on the other side. Interest for you to rebut.
All right.
Do I get a question?
Would it be possible for him to see his rebuttal time to me? I'm someone directly inflicted by this. I was a candidate last year in the off-campus large district who, no? Understandable.
Not in this case.
Understandable.
You filed a petition,
But
right?
yeah,
Okay.
Thank you, Tyler.
All right, thank you.
I think a lot of parts of this case that are like, I think my main issue is, like I said, as we mentioned in studying it, I think the issue of, I think political will is a whole different definition of what's being used here. As a right to city by the Constitution, I have right to vote, different from being represented, voice heard, which by voting, your voice is being heard in some way, versus the outcome of the election. I think that just to me, I don't see how you can grant that, because does not, it doesn't relate in any way. And I just think the facts of Lewis and other cases, the hurricane, these facts aren't aligned closely at all, because every off-campus student being able to go to the polls and put 2 buttons and cast their vote, send it in. There's no impeding the right to vote there.
Yeah, before I wonder, I mean, really how we would decide, how we would look at the evidence and determine whether, something unfair. I think we should start with standing, and I don't really think it's, not, comparing to precedent, the facts of those cases where actual voters who went to the poll and had their vote impacted somehow, that shows, it satisfies a severe concrete injury as required. This case is just alleging that one system that's in place now is unfair, and that's injury is, the ties are just not close enough for us to really get past.
Yeah, I think that's like the question, like, we don't know what unfair is. Like, there's no actual injury here, like you said, like a perfect plaintiff would be someone who ran, won, didn't run.
Yeah.
So we can't really have, there's like no contradiction.
This petitioner has to have a particularized injury to him, I don't think this, snagging electoral fairness and system, whatever makes it Lewis, the standard of review is connections with what, they can vote. So threshold, there's no standard, in my opinion.
I concur with that. Alright, we'll start with the one and only, claim for relief, I, Justice Turner, deny.
I, Justice Sotoro, deny.
I justice Gordon deny.
Oh, yeah, excuse me. Let's stricken that from the record. I, Justice Turner, this is for dismissing or keeping the case open, on standing. I, Justice Turner, dismiss.
I, Justice Sotoro, dismiss.
Justice Gordon dismiss.
Justice Kessinger dismiss.
Alright, that's a wrap.
Thank you guys for coming today.
Thank you.
Thank you so
Good
much.
arguments.
Also a great speaker as well.
Yeah,
Thank you.
lots to go through. You did a good job.
Yeah, did a lot of words.